See, if we stick strictly to the topic, then nothing much is to be said. Appreciation and recording of electronic evidence is no different to my understanding than how we appreciate the other laws, except a little changes out there. Keeping in mind the Section 65B, a much debated and much litigated provision in the electronic law. In the light of IT Act, it provides a chapter on offences. It's a substantive offences that provides. So in the light of the IT Act, we just need to deal with what the ingredients of the offences in the IT Act are. Otherwise, appreciation is mostly based on Evidence Act only. Now, one thing that brings, maybe perhaps the Honorable Chief Justice thought that I have been nominated for too many electronic evidences courses, then I should go for this as a resource person. That was one of the reasons maybe. Lordship had called me also and I couldn't say no. I said yes, I can do it. But I looked at the participants. It was showing District Judiciary. Had it been any other police or that, I would have easily come. Okay, so it was a bit of awkwardness. As I still remember the then a very vast experienced Honorable Chief Minister, the former, who whenever in the program in Judiciary used to say that is the only place he fears to speak. So with so many learned judges in front of me, there should be no lie, even by way of common sense, I guess. So let us begin that way. So one of the things is, one of the established principles of the criminal law and the Evidence Act is that the fact speaks for itself. And it is often said that witnesses are the ears, nose and eyes of the judges or of a fact. But this does not hold any relevance when it comes to electronic evidence. If you see the definition of fact also, it means fact means and includes anything, state of things or relation of things capable of being perceived by the senses. So now when it comes to electronic evidence, though we perceive certain things, but its genuineness is always a doubt, especially in today's world. If you see the cases out here, still we have not dealt with any such major, forged electronic evidences. The forgery is to such an extent that you will have to disbelieve yourself what you saw. So the forgery can go to that extent. It can, literally speaking, rob your senses as a judges. You may say that the evidence produced before you is absolutely looking genuine, but it may not be. So the technology has reached that level, and it's just a matter of time that we will be having such type of cases in very near future, where a judge will be dealing with such kind of evidence where your senses cannot perceive its ingenuineness. So that is the whole difficulty in electronic evidence. And as we have grown as a law, not only in Indian jurisdiction, but even in foreign jurisdiction, the law grew in a different way, outside the electronic realm of evidences. And we are adapted to that. All laws are based on what are the material objects and the material statements or the documents that come before us as an evidence. It's a new thing when electronic evidence comes to us. Though we have that there are certain objects arranged in a certain way in certain place is a fact. Okay, this arrangement out here in the court is a fact. I can see it. No one can deny that. No one will believe if I say Jyoti Madam is not here. No one in the good senses is going to believe. But in electronic evidence, if Madam was appearing virtually or some kind like that, then I could say that Madam is not here, though I can perceive that the Madam is here. So this is the very much challenge in dealing with electronic evidence in the court of the law. It's difficult to believe what is being sold to you. Okay, and it's not that in judging we just look into the laws. Many things play on our background. If you remember, while writing judgments also, you don't write everything what is there in your mind. Sometimes we intentionally skip to write something, because saying that means pulling in so many other things, or leaving it at that level without saying something but still giving out the meaning. That's how we write judgments sometimes. But in electronic evidence we have to give everything. Okay. Now this example also, that a man heard or saw something is a fact. Now the Evidence Act of 1872 deals with the evidences in this way as a fact. But in electronic evidence, it may not be a fact what you heard. Okay? That a man said certain words is a fact. This may still not be true. And all these evidences will come in the electronic form. Some witnesses also might say, and I saw this in an electronic device. That may still not be true. That a man holds a certain opinion, has a certain intention, this is also gone, because the electronic records, they do not have censors to hold any opinion or whatever it is. So what we have been presented, even if it's an object, it's something which has no identity of its own in electronic evidence. So this is the difficulty, and this we are required to interpret and appreciate. And appreciation also becomes quite difficult if we are not well versed with the terminologies used in the electronic gadgets. Let's take, for example, I had a case of forging ATM machine. There was lakhs of rupees gone from the ATM, and the accused persons were two of the employees, because if refilling of ATM is not done by banks. ATM is not under bank's control. Refilling whatever, it's taken by a third party. I think it is SIS something out here. There are many such agencies which do this job. Bank just hand them over the money, but one of the rule was that there has to be both of the persons who go and fill the ATM machine. If only one is there, it will not work, and each have their own codes. But practically, things work differently. It may not be possible every time that both should be there. So one fine day, one of the fellow gets sick, but the ATM machine has to be filled. So only one person goes to the bank, and the bank, codes are not to be said. But these two persons, they know their codes, each other's code. Practically it happens. Both of you going every day together to fill in the money, you should know each other's code practically, right? And apart from you two, no one else can rob also by that process. So sharing each other's code also doesn't matter. That both of you both conspire, you can steal the money from there. So bank also hands over the money, not in a formal way. They did not keep the record that both of them are not present. So informally bank hands over the money, okay, and one person goes and money is filled, no problem. Many months go by, and then an audit of ATMs also by the regional branches of the banks, how much money was gone. Now, one fine day they find that from about 6 or 7 ATM machines of different locations, ranging from MG Mark to Ranipur, of a particular bank, the amount is not matching with the ledgers, and two of the persons were arrested. In this case, I found that there's so many different terminologies used. You have to understand the machine itself. Otherwise, what the person was saying, it was so difficult to understand. So, these are one of the challenges. Let's say ATM machine. Anything it is producing is an electronic record. Okay, I did not deal with the judgment. Later on, my Mr. Benoy came over and she took the case. I do not know its outcome. But what I am trying to say is, as a judge, we all know that we must have knowledge of everything, even mathematics, to a certain extent, right? Challenges might come. So, to have knowledge of ATM machine, so I had to ask the witness, almost it took my whole day to understand what the person is doing, because they would usually use the terminology, the banking persons. You would not understand that. Again, you will have to ask those questions. What do you mean by that? How does it work? How do you feed the money? What are these codes? And what is printed? So, all these comes into your record, and you have to appreciate this. If we do not possess the knowledge of how it works, then you will not be able to appreciate these evidences. So that's just an example of ATM machine. There are so many machines as of now. Anything might come before you as an evidence in electronic law. So appreciation, basically, if you go by Evidence Act, okay, is the witnesses will be coming and speaking if they are humans. But when it comes to electronic evidence, there is no different set of parameters prescribed in the law for appreciating electronic evidence. The only thing is the knowledge should be there to appreciate it and how to take it forward as an evidence. Now, before moving forward, why electronic evidences are so much scrutinized? It's just because it's hard to believe it what is produced before you. We don't scrutinize a original document brought before us so much. Oh, signature is there, executing witness? We all know. Okay, believed it. But the moment electronic evidence comes, then that's quite a problem. So far we have not had such kind of forgeries, but mind you, when we go in training, such forgeries are shown that, I personally felt that I am in a prehistoric age. Such as the magnitude of these offences on the using electronic means has increased in cities like Delhi, etc. And thankfully the training personnel there, cyber experts there are very, very good. One of our course was taken by an IPS officer, a senior IPS officer, and the way he, lectured us in the subject was so good that I felt someone like there was no difference between us and he understanding the law. We in the court understand law more, it's practical, and the person also, without having any practice in the court of law, knew the law so much and how it works in the court that it was surprising to see that from a person of IPS level, which you don't find out. So these are all exposures. Okay? We are out here not dealing with many of such cases. Therefore, we are not exposed to much of the vagaries that may come with it, or experience also. And with it, the cyber forensics also come with such cases. Out here, cyber forensics, the opinions are also very less because of very less such cases. And one of the things that has become most challenging in the electronic is tracing. Now if you see the IT Act, all the offences begins with the word whoever. If you see other laws also, it says whoever. But the perpetrator in using electronic means, perpetrator of offense electronic means, is untraceable. So the very word whoever goes haywire whenever such offences come. If we have all seen out there, the first thing that the investigation officers here, at least here, cannot do is find out the person only. All the Facebook cases are final reports. We know that, Sri James would know that. Except one. Can anyone tell me? What is again brought as a charge sheet forcefully, even when it involves Facebook, is all those, alleged defamatory contents against a politician. But I've seen cases where nudity has been published everywhere, morphing the faces, and the police come within 15 days with a final report saying that we could not trace. But they give their everything when it comes to defamatory allegations against politician and somehow make a charge sheet and come, which does not stand in the court of law, to be frank. They just filed it to please someone maybe. So the traceability is the major problem in electronic law. Forget about appreciating the evidence. You don't get the accused one. Now, I feel how many of you and knowledge seniors have heard about VPN? VPN? It's a common used word. In the court also, I think we have one of the net connection is VPN. VPN is virtual private. Even I didn't know it. I heard this word until a few months back. I used to think it's some kind of internet network, but it's not. Now VPN is, we can say it an intermediary. It's a software actually. Why it's called virtual private network is the net which you use through that software is only yours, but it's virtual. It's called private because it's only yours. Okay, but you might question that. Let's say I'm using a Airtel mobile network. The moment I switch on the VPN installed in my mobile, the service provider is Airtel, but that network, the connection which my data goes, is virtually untraceable. It goes to any servers in the world. It can go to, you can choose this country also where your IP address will be located. So this is usually used VPN, right? Yeah, you can call proxy also. And there are different types of VPN. I have installed one I took advice from one of the computer person, and he said this is the best. So there are different types of VPNs. You have to purchase it, right? It routes all your mobile network through that software. And the one which my one gives automatically is Malaysia, but I can change it. And even when I search in Google, it gives me all the products in Malaysia. So I have to switch it off for at least 5 minutes, pause for 5 minutes, then again. So it's such secured. It entirely takes my source to Malaysia. And if the enforcing agencies here have to find out, even if they trace Malaysia, the next bigger thing about VPN is even if they trace Malaysia, okay, they will not be able to locate my device because the IP which is provided to my mobile is a masked IP. It's not my device IP at all. So I am untraceable. Nothing in the world can trace me from where I am using the mobile, because once the IP connection is masked, my device is unrecognizable. So it works that way, okay? So this is usually used by an expert criminals, not the ones who are posting out here in Facebook. Even let's take suppose I have VPN on and I post something in Facebook, okay, with a fake ID. Of course, if I use my own original Facebook ID, then obviously from that point they will know it's me. But if I create a fake ID with a VPN on and write something, they will not be able to trace me at all. First they have to go to Malaysia. Even if they reach the server, the IP is incorrect. Let's take for example, which will not happen, just presuming they trace the IP also, they will not be able to encrypt the data, what was written. And this has to be proved in the court of law. No police can come to a court and law and say, this is what he wrote in Facebook. Electronically he has to prove that I wrote it. And when first your server is somewhere, okay, though I am using Airtel, the Indian service provider, but my data is going to server in some other country. If the police reaches that server, it's a masked IP, they will not be able to locate the device. Fortunately, with some heavy luck, if they are able to locate the device, they will not be able to encrypt what I wrote electronically. It may be there in the Facebook in the English language form, but they'll have to prove what I wrote it. So it's gigantic. I don't think it can be proved anywhere in the world. Unless, and it's not only that, electronic evidences are dealt with 65p only. All other rules relating to evidence also has to come to place. Let's say it's circumstantial. The chain of circumstances has to be proved by electronic evidence only. The moment it breaks, no matter how much electronic evidence you bring, it's gone. So it's not that, we appreciate the evidence of electronic law only with the rules relating to electronic laws or 65p or something else. All the other evidences act also must come together to prove a conviction. That's the principle of law which we have. So appreciation requires all this. Bringing in evidence may just require the rules relating to electronic law. So VPNs are usually used. In fact, about, I think last week it was 7 days, a week or 10 days before, the website of Supreme Court, there was a phishing website available in the network of the Supreme Court. Now phishing website is that, you just create a website. Now phishing, all the spywares, malwares, this contains program, okay? And it depends on how much cost the person has put to develop this program. The costlier it is, the more undetectable it is. But phishing websites usually, if it's a low cost one, by looking at the first page only you recognize if you have been usually visiting Supreme Court website. It looks a little bit of different, somewhat your senses can tell. But if you're not vigilant enough, you might give all your data. Now what's the purpose of this phishing website? Usually I think someone, try to do mischief by creating a Supreme Court phishing website. We are going to get nothing out of it. We don't put our personal details there. We just either search cases or whatever it is. A fake website can be created by all this. Usually these websites are created to extract all the details of credit card, debit card from the persons who are e-shopping. Now there's a fake website, you think it's Amazon, you go there, you track everything of yours. Okay, in the end you will be putting your credentials. Now how we can detect this, one more thing is, if it's Amazon or Flipkart that you are using, you usually have your certain things saved up there. You need to insert CVV and the OTP comes. right? Otherwise your cards are saved there. Unless you have pressed, I don't want to save that option of not saving your card also there. So this phishing website do not have your details. So first they'll ask your card, and it should be a red flag for you. I shopped in this website before. It never asked for the details of my card, it's asking you. But if you are not vigilant enough, and mind you, the forgery and the fraud that can be committed through electronic means is that no one can say that I'm clever enough to avoid it. Right? So the techniques are used. So you put the credentials, gone. Your material doesn't come. All the credit card details you put is captured by them and taken out. And OTP, there are several mechanisms of getting your OTP also. There are manual mechanisms like calling you up, etc. But let me tell you one example. Once what happened was, the disadvantage of it was, even genuine people, they face the difficulty in this. Once I ordered something, but the last digit of my mobile number went wrong. It should be 7, it was 8. So the fellow, I ordered in Siliguri, I got a call, I was not there. The delivery boy asked me for OTP. I said, OTP has not come to me. So he said, this is your number? No, the last digit is not mine. Now it won't be delivered without OTP, right? So I died with that last 8 number to whoever it is. I said to him, see, this is the situation. I'm a genuine person. I put in the last digit. Can you give me the OTP? He refused. Rightfully so, no? It could be anyone. And I was furious, so I was trying to explain him, no, it's not, I'm giving him all my identity. But still he didn't give. And the other time, the same thing happened. Someone had put a wrong number and it was mine. Even I didn't give, because even I was not sure whether the person calling is genuine or not. So in OTP, one of the biggest frauds that, there are certain codes, and we were told, even in airports, these fraudsters work inside the airports. Now why they have chosen airport is the reason that except Pegasus, we'll talk about Pegasus also, except Pegasus, all of the software, that's why Pegasus is considered so dangerous. It does not require your doing of anything to get spied upon in Pegasus. But in all other things, we have to make at least one mistake to get spied upon, or something to be installed on our mobile phones, right? That's the only difference they say about Pegasus. You need not do anything. It comes to you. You don't touch your phone also, it will still spy on you. And then in airports, it can be done anywhere. There are certain codes which I didn't bring today. They had given us the codes. We had tried it practically also. It works. Suppose what one person did was, he was in airport, and one person comes and says, see, my battery is about to drain in my phone, and I need to make an urgent call at home. Can you please give me your phone? He shows his battery at 3%. Anyone would give. Would you not give? I would have given. I placed myself in the place, someone acting, and don't think that, they are acting like me. Their acting skills are also very good. You will be fooled by them. Karmasa would have given both phones, I think. You would not think twice. Anyone may not have thought twice, okay? So the phone is given, and then, he pretends to talk. Obviously he will not dial the number. I'm dialing this number, he'll not say, he'll just dial certain codes, okay? And then your phone is compromised. And this was a trick of, taking OTP. Now, how do they take OTP? Now, every time it doesn't work. It's, a trial and error for them also. OTP will come to them, definitely, once they put that code. But without you knowing it, what they do is they divert your messages to his phone. You just have to dial the code and his phone number to divert all your SMS to his number. But there are certain conditions for it. When not reachable, okay, when in flight mode, etc., etc. So this is one of the methods of, hacking OTP of a person. Now you would not know. Your mobile phone might go anywhere on it. Now this is not a small scale business, a person trying to steal one time, okay? It's a huge business. They are working 24/7 in some call centers, monitoring all your things. The moment it comes, they will now try to transact through. They will now try to attack you, attack all your personal, get all your personal informations. They might install the spywares also. Okay, someone might, okay, you get the phone, right? Then, okay, I'm so and so. Can you share emails? Okay, in airport we don't doubt people with some people coming with suits and tie, well-dressed person with Reebok, Nike shoes, etc. Okay, so we get friendly and change the numbers. We start communicating in email, and there's a spyware. So it's not just OTP thing. It's a large business of getting everything about you, and not one person working at one point of time. Many people working. I just gave an example. So this is how, because I'm surprised, because I always felt that no one can take your details. Till date, I have not been robbed. I have been using so many e-commerce websites. A bit of careless also I'm there, but I have not been robbed. But I have found some people saying, I didn't do anything. I doubt them still. They did something. But it could be possible. It could be possible that, which we don't know, without doing anything else, it has been taken. Because most of the people will tell you, even in court, if you get these cases, they will tell you, I did nothing. They may have clicked some link or etc., which they are unaware, This is how the data stealing goes. And as I said earlier, if anyone knows more on Pegasus can tell, Pegasus is I think it's Israeli, meant for government spying, for government does spy, okay, which are sold to specific government organizations for a good purpose. And I think that's true also, that certain Indian individuals, high-level individuals were targeted with that, and you need not do anything with Pegasus. That's its lethality. It can use your everything, including microphones and so. You may be sleeping, your camera gets on. So you're monitored 24/7. And will not know. And one of the other example, to install, it's very easy to install a spyware in your mobile. So just have to give your mobile once to us, whoever is installing, once. You can purchase all these spywares, and the moment you purchase and install it in another person's mobile phone, then you get all your data. So it depends on the cost of the product. The more costlier, the more data I can have, including WhatsApp chats. Okay, no, this chat, you have heard that and you have read also, it's end-to-end encrypted. Of course it is. But this spyware is spying on your mobile, not on WhatsApp. Okay, the data. Suppose you're in WhatsApp, your autosave is functional. You have put it on, autosave photograph. You can off it, switch it off also. No photo gets. Now on the saved portion, that is compromised. The spyware will access your gallery. From there it will take it. Okay, not from the WhatsApp itself. And if you have screenshot your chat, everything is there. And if you are talking over it, okay, then it will hack the microphone and hear all what you are saying. You have saved your recording somewhere. So these are spywares. It can be installed in iPhone also. iPhone has a specific websites which sell spywares for iPhone, especially. Okay, you can purchase it. If you see it in the Google, you can do it. And it is said that the most common cases that are found in spyware is between husband and wife in cities. And how did the husband install is that he gifted a very costly phone to his wife. Though where is doubted, and he at home uses the software. It could be she also, okay, and then looking all what the person is doing. It's cyber stalking and offense, right? So this is spywares. Now these all present challenges. Now if let's say cyber stalking offense is registered in a police station or it comes to a court also, you'll have to prove all these things. Purchase of spyware, just like if it's a murder case, someone has purchased knife, police will try to find out who sold the knife. So the means and method is the same. The only thing that is coming to us is the electronic evidence, and it's absolutely difficult to get it through. And just because before going to 65B, all these things are really essential to be known, so that we will find that 65B is nothing, it's just a piece of paper. It helps us nothing. It's just for a formality's sake, it is there. Now, another thing is, I think all of you have heard about dark web, right? There's a clear net, we call it, which is like Google and all, which is at the surface level. Now, below it is a deep web and then the dark web. Now, what would be the difference? Why we cannot access this dark web, etc.? It requires a special browser and a special software to use this. Now, there's still one more we normally can use is a DuckDuckGo web browser is there. It can still take you to some of the dark webs or the deep webs. But dark web contains all those connected networks of computers. Now, what is internet? It's just internet connected. Okay, all the data are available in the servers through computers. Now, these in darknets, the browsers allow only those users to come in whose IPs are masked. Just like if I use VPN, I can go to dark web, but I need to have certain browsers which I don't have. Okay, there is a one Tor browser which we have to purchase it. I have not purchased it yet. So it's combination of a special kind of browser software masked IPs. With this VPN masked IPs, I can still go a little bit inside because that browser recognizes I am masked and it allows my traffic to go through that particular search engine. Once it finds that you are not a masked IP, it's a genuine one, that browser does not take you to those connections where a different type of data are available. So in Google, we get all those things are publicly accessible, from all those servers. Okay, and even if you use a masked IP in the Google, it doesn't matter. It does not differentiate between this. But the further you go down, there are certain criteria within which only such users can go there. Once you fulfill that criteria, you can also access dark web using things that is required to access it. Okay, and then in dark web, I do not know if you can use DuckDuckGo and type buy cocaine online, you should get it, because DuckDuckGo still does not insist on having a masked IP. So just this morning also I tried it. It takes you a website in USC. You can add to cart cocaine, how many grams, but you have to pay in bitcoins. Okay, but in Google you will not get this. Google you may get some phishing websites saying so and so, but you will not get it. Now if you have that DuckDuckGo, you can try it right now also. You can see, you can buy cocaine online. And that is just one tip of it. Now DuckDuckGo is giving only one, I looked at it, only one seller. If you go further deeper, you will get hundreds of sellers. And what not you can buy on the dark web, you can buy everything. So this is the magnitude. Now someone would say, then is it not illegal? See, selling is illegal through the dark web, whatever they are selling. But dark web itself is not illegal. It's just providing a service. It's just a browser. It has certain criteria. Dark web was not meant for selling these things. But these sellers, they fulfill certain criteria and enter that and get connected to that web browser. And even if I purchase a Tor browser, which is used for accessing dark web, and the name sounds some kind of illegal, but it's not illegal at all. It's just like Google, which provides services at the superficial level. It's just like Google only. This Tor browser, Onion browser. There are certain criteria from where you can enter that. And that dark web is not meant for criminal activities. Even in the superficial net, there are criminal activities going on, right? You'll find porn sites even in the Google search also. There's no problem with that. So the Google is not illegal, no? It's the websites, those are illegal. So this is the same thing in the dark web. What comes in the domain of that particular web is a different thing. Anyone can come. And whoever comes illegally, that particular is doing illegal activity, and not the one that is providing the service of accessing the dark web. As I am saying, it's just the name, okay? It's deep down there, that's why it's called dark. It's just a misnomer. Dark doesn't mean bad or illegal something. So, activities happening here. We are unable to deal with the electronic evidences that are coming at superficial level. Then leave alone the question of dealing with the evidences that come through the collection of evidence that occurs in let's say, one of the cases that was told was cocaine was regularly being ordered at Hyderabad through dark web. And the only thing that the police could do was, but it will come through either courier, if it escapes the enforcement agencies, then it escapes. If not, now I think if you spend more money, it may come through special sea routes and directly delivered to you at home. That's a different issue. But usually, small scale buyers would order it through the couriers, like blue dart, etc., and it comes. And some of them do get caught, and the only evidence police has is it was addressed to that person. Nothing more. You cannot convict with this much. So it's a difficult thing, electronic evidence, if you have to deal it actually in the court of law. I don't think convictions are possible. What would happen? The AIMS malware attack, AIMS hospital. One day what happened was all the computers stopped functioning in the AIMS. No registration of patients could be made because everything there is electronic in AIMS. One patient's details moves from one place to another through electronic means. Even in private hospitals, even in Siliguri, you see, everything is electronic. So one fine day, the computer stops working. Neither you could make an entry, the whole system stopped. And still the police could not trace who actually did it and for what purpose. No one claimed any ransom also. So it could be mischief, some trying to it, because we were told that the world's best hackers are teenagers. And it's not that they have gone to some great computer classes. They are just playing with computers since they started knowing what is a computer. And we have become old, to be frank. What do we do? We just search some e-commerce site. It's a whole, universe of knowledge. A computer is a whole universe of knowledge. One man need not go to school also. In future generation, I think so. And the traditional knowledge that is being imparted in school may not work. In future, we may not, with an LLB degree, we may not be qualified to become a judge also, unless we have some course in computers. So it could be this one, the teenage mischief makers who just wanted to show their skills, try their skills. And we were told that these people are always one step ahead of the law enforcement agencies, and we know how law enforcement agencies work. The moment something is implemented in them, it requires a huge infrastructure to fight these offenses. You cannot have a single person fighting with it. So they are always ahead on this too. So thankfully, one of the best things that helped AIMS was they had a backup server. Okay, so for about a week or so, the hospital got completely paralyzed. Sir, it was to such an extent, life-saving surgeries had to be postponed. They couldn't do it. No details, no data, which doctor is coming, who is to perform, who is on leave, everything crashed. So it took about 7 days for them to restore from their backup servers all the data. So they said that was a lesson to them. And they are looking into, no data is safe, including our e-codes. So in the e-codes project, they are thinking of, encrypting this data using blockchain technology. What if one day suddenly all the judgments that we have posted is gone from the computer? We cannot get it back. We will write another judgment. So the backup servers concept is there. And if I may tell one more thing about you, recently I think from academy, they wanted to remove their hosting of website from the main server of NIC, which is there in New Delhi, because updates were not coming. Now why NIC? Now see, you have heard about cloud computing, right? Cloud servers. Now cloud servers are located somewhere else. You are feeding data from here, but all your data goes and gets saved in somewhere else. So what the NIC had done is, they have a main server in New Delhi. Now that server is not connected to internet. Now why? Can anyone tell why it's not connected to internet? The main server. Without internet being connected to server, how will you access the data out there? To protect itself, because such is the threat and such is the data it has of the websites of the entire government institutions, that one attack will throw away everything. So they have cut down the network connectivity there. It's a virtual server, okay. They have cut down the connectivity because without internet connectivity, no one can attack. There must be the internet connection to attack that server. So to avoid that, they have cut it off. Now the next question that might come to you is, Well, if this is cut off, then how will we access the data? So what they keep there is the only essential data, like updation of website, if certain changes are to be made. Okay, and they do it manually at intervals. They go connect the network, and whatever updation is to be done is to. Now it's a government function in NIC. They have stopped doing it manually also. So now their website is so outdated. Neither they can update it, because to update there must be a connection with the server there, which they are part of the internet. Okay, and there are other virtual small servers which they have kept outside. Up to that point only the access is given, and it has very limited access. Operation etc. are not there. All the operations are in it. So this is how a server works. Okay, now to avoid attack, they have cut down the. This is one way of protecting your servers. But servers cannot be kept out of internet network, because accessibility, all the data are there. Now, if our server, they say no, server is down, it means your connection with the server is not there. Once the server is down, you will not have access. You will not get. Suppose you want to find your judgment, you will not find your judgment. Server is down. So there must be some mechanism, some defense system to protect these servers without disrupting the internet connection to them. Now it's a crude method that NIC adopted of stopping the internet connection itself to the main server. The website works because there are other virtual servers get outside of it, up to there. But when they wanted to update it, to upgrade the website, whose data is there in the main server, they could not do it, and they asked us what. So we have advised it to be changed to the NIC mini server we have at Gangtok itself, which has continued internet access, and they have assured at their own level the protection of it. And but as I said, it's still vulnerable to all the things. So actually the NIC have given up on that main server. Now they are using this concept of mini data center at different states, and actually it's their ploy also to encourage all the states to use their mini data centers. So this is the magnitude of electronic thing. Now let's Kamaso would like to say something. Please, sir, you have such a vast experience. Even sir is a master trainer and has been to certain electronic evidences. Anyone who have been, I think some of the judges have been to electronic evidences trainings.
I have nothing to supplement, but I think it is true that for any judicial officer or even law enforcement agencies and the prosecutors, the understanding of basic terminology is very important, because without understanding the basics, we will not be able to go to the second step of appreciating electronic evidence. And I think we should start from basics. I think what the resource person has highlighted about the darknet, these are also important, because unless we understand what is darknet and how it works, we will not be able to understand what kind of evidence comes before the judge and how does it operate, what is VPN, what is, these are all platforms like the Tor platform or the Onion. These are all platforms like Google as to how we access, or how we browse. These are all browsers, the Tor or Onion that you talk. And there are, I think, countless, even I've forgotten now. But generally, I think we should understand these terminologies before we really understand or appreciate the evidence. I think that is what I wanted to.
And two more posing challenges in dealing with this law is, of privacy also. It's not just that when we talk about electronic evidence that, in future, once the electronic evidence comes, now also, apart from the traditional offenses, if you see, 420 is probably all through the electronic means, right? And I don't think there has been any conviction in our state where the major evidence was electronic evidence, even in 420. There has been no charge sheet on it. And the question of privacy, I have a VPN network. Now someone might say, I just said that, the It's usually criminals use, but VPN was not developed for criminals. What I considered was it was my privacy. Now the phone, it's almost half of your life is here. Your details, data, everything is here. So why should I compromise my privacy? Okay, potentially offense can be committed from here, as I said, without the law enforcement agency being able to, track me. But the more concern of the one side regarding electronic evidence is of privacy also. So that is another challenge, in bringing out the evidence. It's just not that you can bring everything. There are privacy that has to be respected also. So this is another challenge in the electronic evidence for the law enforcement agencies, whether they could bring everything, whether they could take your mobile and do whatever they want to do. They cannot. The other laws would prohibit it, And how would the Constitution, the article that you cannot be a witness against yourself, would work in electronic evidence is still very far away. A day will come when, again, this will be another hurdle. Because if you see, having CCTV everywhere is well, fine and good. But I personally feel that, I'm being monitored every time. Okay, so, and nowadays police are encouraging to put CCTV, well and good, it sounds very good. But we have no, except inside our room, there also, spywares are compromising it. Otherwise, privacy doesn't mean that, me not doing bad thing. Me walking down the street on my own, with my changed behavior than what I am required to maintain before certain people is also a privacy. I have monitored everywhere and it's under no one's control. CCTV, they can do anything with it. Right, so these are all the aspects that comes when it comes to electronic. It sounds very good. Oh, CCTV inside the case cracked. But people may be monitoring you to make you a victim also. So all these things are not taken into account. We just look at one-sided. So electronic evidences is not just that the production of evidence in the court and that is the problem. These all are used problems. And it might arise in any court of law. Now, till now, we have constitutional courts to decide constitutional issues. But with these electronic evidences and right to privacy being such a natural element of human existence, that one day trial courts itself will be facing these questions of whether privacy was violated or not. So these are the general aspects of the problems with electronic evidence. It's not just about 65B. 65B is nothing, like we'll go there at all. And still, it's still kept there because it has a limited purpose, Otherwise, it helps you nothing in the court. So, there's one more. It's up to 11:30. Lunch is at 1:10, no? Okay, so appreciation of documentary evidence in civil and criminal case. I do not know whether it's in the context of electronic evidence or it's a separate topic. It appears to be very separate, is it so? See? Huh? I think learned judges are also aware of the rules and the liability of intermediaries. That is very essential. No. Rules. Is Facebook liable for posting what you posted? No, they are liable. According to the Indian law. They are liable, but there are certain conditions. You can't make them completely liable. It's the words economy will rest on. That aspect also the legislators keep in mind while framing these laws. Okay, TikTok was banned because they said it's Chinese. Okay, but WhatsApp, Facebook, Twitter, they have more pervasive in the Indian subcontinent and at various levels. TikTok maybe was at different lower levels only with some youngsters, but all these three are with everyone, even an old man has Facebook. So yes, these intermediaries, this is very important. This might come in the court because Facebook would say, see, I'm just an intermediary. I just showed what the other person did. So where am I in the picture? I did not develop Facebook for someone to post defamatory comments. If he posts this, that is his problem, not mine. So this was a major issue behind these rules of 2021, giving liability to the intermediaries. But there are two catches out there. Initially, there was a judgment of when this became issue. Now these companies will fight these cases. They don't want to be called to the court every time, including the trial court, for doing their business. So they fought and said, we cannot be made liable. So the legislation also gave them some way. If they knew that such post is there, now why the legislators wrote the word new? Because they are supposed to know, right? They deliberately used, if they had the knowledge, the word used in knowledge, that certain contents defamatory in nature is there, they should remove it. They put an obligation upon them. Now, what does this knowledge mean? Again, this was a problem. To what extent? What is the area where I should have knowledge? It was posted yesterday 12/9. I do not have the infrastructure. Now, it does not only involve Facebook. Facebook has a huge infrastructure. It has huge monitoring mechanism. But it does not mean that I, as a software developer, cannot create a software like Facebook. I can at my own level if I can create. Okay, I may not be having huge infrastructures like Facebook. So suppose I create a software, okay, called just book, similar to Facebook, a very rudimentary one, which people start using, and one fine day someone posts something wrong there, and I would be brought to the court and say I am responsible. I would say I don't have that infrastructure to monitor. It was posted yesterday 12/9. I have 3 people to monitor it. I created software myself. So I acknowledge only right now. I acknowledge right now, I'll remove it now. But the damage has already been caused. So it depends. It was very subjective. Facebook could be held liable within this realm of knowledge, that you had the knowledge that it was there because you had used infrastructure. You were supposed to have knowledge. But I could not do the same thing with some small companies which did not have that infrastructure. I got the knowledge only later on, the person could say. So it became very subjective. So in one of the judgment, court said this knowledge means when it is brought to your notice by the law enforcement agencies or by the court order. That means when you receive these things, your knowledge begins and now you are obligated to remove it. If you don't remove it, you will be liable. But later on, yeah.
Something you have to report it. So provided you report it, then I'm sure it is deemed to be in the knowledge of the Facebook.
Of course. That could be termed as one of it. But how the court said was, they said legally. Legally, because these people were challenging, that is for their purpose. Okay. Now, court said exactly what we are saying, individual complaints cannot be treated as giving knowledge. Okay, there's one judgment which said so. Now here the intermediaries became very happy. Because why this problem came up was you could not completely, fasten liability on the intermediaries also. It was their business. They have a right to trade under Article 19. Okay, if it's an Indian company. So you cannot completely stop. So a balance was tried to be struck. What does it mean by knowledge? The word knowledge in the legislation was too big to be interpreted. So they said either when the law enforcement agencies gives you a notice that you have so and so content, kindly remove it, or the court gives an order saying that you have so and so content, remove it. From that point your knowledge starts. That happened. But later on what happened, it was a developing thing. Later on what happened was there was one website called Darviz, which was selling foreign products in India. Now, the products which were being sold to that website, the brands said that, no, the fake products are being sold through this website. And there was a suit, a civil suit. Now, Darviz said that, see, we are just intermediary. We are just importing, selling the foreign goods. Therefore, we cannot be held liable if the products are ingenuine. As an intermediary, right? If there could be a difference. But what the court said, now there was a problem in this. Now, when they looked into the Darviz, that's why knowledge and all these things are very important. Darviz website, it looked as if it was the brand manufacturer. It was advertising the brands. It was saying, yeah, this brand of particular brand, I do not know the names, okay, is very good. If you use it, we are going to get so much changes in your face. It was a beauty products mostly. So the court said, no, you are just not an intermediary because you are promoting that brand. It was a civil suit, okay, and this Darvis lost it. So this, the idea of knowledge, the word knowledge also, was not only limited to particular kind of intermediary, it differed as to what was the intermediary. If it was the e-commerce intermediary, it had to be interpreted differently, the word knowledge, etc. So Darvis could not escape the liability as an intermediary, and I think they had to pay a huge amount on damages because the court held that. Court was bound to held that actually. If they would not have held that, then Darvis could do anything. They were advertising the products. Now if you see Amazon, they don't usually advertise the products. Okay, there are certain things, iPhone being sold in this one, so and so. That is essentially not promoting the brand. But Darvis was promoting the brand itself, and therefore it was compared as if it was a brand itself. Therefore, selling the products which were not genuine did infringe the brand's copyright, and then they were made to pay the amount. So even WhatsApp, I think it's still fighting regarding the liability of intermediaries. I think the case is still in the Supreme Court. They don't want to come under this at all. No liability for them. So initially the rule which was made, I think 2018 was a very strict one, but the India government had to come down a bit so that these commerce industries do not go. The biggest problem why this intermediary rules 2021 came into being was that the Indian law enforcement agencies, when they were writing to Facebook, they were not getting any data. Okay, and Facebook, WhatsApp, Twitter, all they have offices in India. Now what the rule said was you are bound to provide it. This is what the WhatsApp is contesting. Because they are saying our servers are not located within your territory. It's just our physical office. All the data is in foreign country, therefore your law does not apply to us. So with these electronic evidences, another problem is of territorial jurisdiction. Who is to give it? But the intermediary rule says no, if you have an office in India, it's deemed to be that your office is located within our jurisdiction, therefore you are bound to give data. Okay, I think WhatsApp is resisting very heavily against this. So intermediaries are liable. In fact, if you see certain judgments, even can we become intermediary somehow? In the loose sense of the word, yes, there are I think quite a few judgments which says, especially the South Indian courts, that if you share a message, you are equally liable. Right? There are judgments. Now this is a debatable issue. I still think that the person should not be made liable for sharing that one. But of course in this also intention knowledge comes. So this is the broader picture of the electronic world which we have around us, and how we have to deal it with is only 65p. So should we keep it for second half? Yeah, it must go better.
Sir, exact title of the room open.
Just let me open one minute. I think it's here only. 2023 should be here. The Information Technology, Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Is in these rules, what to do. IT Act substantive offense ka cha. Evidence Act le procedure bataउँछ. But what we can do and what we cannot do is in these rules. That's why one of the arguments, what the WhatsApp is giving in the Supreme Court. Just what I said right now. And it seems a very valid argument. I think the court will get stuck in this. They have said, rule is a delegated legislation. And it is more enormous than the IT Act itself, which cannot be done by us. This rule is made by the executive. Your rule is so big, it regulates so much than the Act itself. How can that be? It's not permitted under the Constitution. It's a subordinate legislation, and a delegated rule cannot be more powerful than the source itself on the argument for this, which sounds plausible. हाम्रो अहिलेसम्मको jurisprudence हेर्दा चाहिँ अब maybe Honorable Supreme Court might say something new to develop to save these rules, God knows. So it's a very valid argument, no? Now one more question which I was asking Sesang and Ms. Mahima also. We have now this new criminal courts practice and procedure rules. Does it talk about document A, B instead of exhibit? I'm not sure. If you can kindly check that. Because they posed a question which none of the judges are here. There's a practice of marking document A, document B of inadmissible document. Is it there in the rules? Have they incorporated that? Because I think so is one of the draft.
I don't think so. Actually, I think
So they have posed the question, we have judges out here, we can discuss. Can we mark document A, document B of a photocopy during trial? So the question is posed by Sesang and they are saying they have not been able to, understand the clear picture. Right? So we have so many judges with experience and Shudira madam is also there.
I think we can mark it for identification at least, yes. Because otherwise, how do we identify it? Because sometimes if there is a copy and then the original is not in their possession and it has not been said also, but then if we require that document, that there has to be something to identify that document.
Can you make more clear here, sir? Why do you require it, no?
Example, there
Which is inadmissible.
there is a photocopy.
Yes.
There is a photocopy. And another thing also, I don't know whether it is probably is not correct, but because we don't follow it that there is a stage admissibility of document.
In civil cases, right?
Admissibility.
No, it has to be followed.
Admissibility
There's a direct high court judgment on it.
admissibility of document is there.
I don't know how do I say it, but okay.
Yeah, order 13, I think.
No. See, when there is a photocopy
Yes.
brought before you, but that photocopy is inadmissible, it is said, obviously. But then what happens is sometimes there is no other document than the photocopy.
Yeah.
Okay, then obviously we can mark it as
Why are you worried about someone else's document?
Document A.
It's party's document, no? Why should the court worry about whether it's there or not?
why should the court worry in this?
Is the party bringing the photocopy?
No, it is the party bringing the photocopy, so the court is marking it for the party only, but then immediately we cannot just mark it as an exhibit or, we cannot just admit it
No,
because it is a
in civil law you
photocopy.
can. Order
Because
13
it
is
is,
clear.
no, because it is a photocopy, neither have they said that it is not in their possession.
That's their problem.
Okay.
No, that's
But
their
then the
problem.
document
Why
is there.
court's indulgence is required? If anyone differs with me, then because it's for them only, no?
No, like for example, I wanted to ask you one thing also. There is one particular case in which the entire case, basically it is about 350 outraging women's modesty, stalking and all.
No, that's
that.
criminal. No, you also.
No, regarding the document I am saying, but the case basically it depends on all the email IDs which has been sent. Okay, so she
Oh,
is
I know
saying that
that.
this person has done this, you know the case, this person has done this person has done this and all, that the email is there, he has sent a copy. But then, अब email मात्रै छ, त्यो 65B के पनि छैन sir. So email छ, now they were saying that यो चाहिँ के भनेर mark गर्छ, it should
Nothing, it cannot be marked at all without
exhibited
65B.
document.
It's gone.
Nothing is there. But then
I am of that view.
I marked it as document.
So why do you mark now? How will you use it that later on? To whom you exhibit it? To no one. You just mark document. It's true.
Document.
Sometimes witness proof the
Because, yes,
there is
because-
copy of the document, but we can't mark that as
Yeah. It cannot be. Because as madam said, secondary evidence on the evidence side can only be brought if you prove certain things under section 65.
The victim came and said that these are all the email IDs which I had provided.
Hmm.
Okay, so I marked it.
Looking at the document,
Looking
that's
at
absolutely
the-
wrong what you did because you cannot give an oral account of a secondary evidence at all.
She said that these are all the
You could not have
documents.
brought that at all.
These are the emails which I have sent.
In fact, you cannot
Which
give
I
oral
given.
account, I think, so I would agree, oral
Which I
account
received
of primary evidence also if it's a document. It has to be proved by document.
She
You
said
cannot
that,
say, oh, this document, this is usually a practice, lawyers would again read it, the contents of a document. You cannot give an oral account of the contents of document.
no,
More so not of a secondary one.
she,
Unless you are allowed by the court to give secondary evidence.
I couldn't get what you were saying.
So why this document is, I do not know.
I
I
just,
feel it's not,
so,
Commercial would know it.
My question is, under the criminal rules of practice, there is no rule regarding marking of documents. There is only marking of exhibits. Because first of all, these inadmissible documents, even if you mark it, will be of no use to the court. So I think that is one reason why there is no provision under the criminal rules of practice. Secondly, it is not irregular or illegal even if you mark it. You mark it, you do not mark it, that is individual court's own business, whether you want to identify it later or not. But these documents will be of no value. Even if you mark it as ABCD for identification, it will be of no value if it is a photocopy or if it is not admissible at all. So generally we mark it only to make the lawyers happy. So that is.
Yes, that's the right answer, I think.
So, two of them have maybe got it. Now rest, how you take it on is when you take the courts.
They will sit on it. Sit on it. They don't copy it.
So they asked me yesterday because rules ma chha ki chaina malai yaad thiena bhare chha bhandama.
No. We all mark it just to stop wasting our time of not arguing with the lawyers. Just make them, all right, you mark it, whatever you want to do. All you want to do is let the court proceedings go on. But there is no provision under the Sikkim rules of practice. And also, it will not be admissible at all. Even if you identify, if you keep it like that, it will just be one more paper in your file, nothing else.
Yeah, in this one, as in civil law, I think you cannot postpone the admissibility decision on the admissibility of documents from a particular stage. I am not saying it's order 13 only. In civil case, there is a Supreme Court judgment which says you can decide the admissibility even at the time of judgment. Because there is no particular stage at which, of course you can decide, we have to decide it when it's tendered. If it's clear, sometimes the picture is not clear for that. But in civil cases, unless the document is brought later on, which we usually do not allow, except for reasons to be recorded in writing, I guess, on the other 13 we have to mark whether it's admitted or not. The more, admission, it's still not proved. Admitted, if we are admitting it, we have to write admitted, name of the suit, title suit number so and so, name of the person producing it, and then signature. And all those documents which we consider as a court inadmissible, we have to return it to the parties saying returned. So that they also have proof that the court returned, and if it is a controversy regarding it, the higher court can decide whether it was really admissible. But this exercise, I think, is Lachungmo lepcha judgment. It clearly says you have to do this exercise at that stage only. So there is no scope of it marking document A or B for later on, because you have to write now in that case whether admitted or returned. So you cannot write on a photocopy admitted. The moment you write it, they will say they have admitted it. But in criminal law, yes, it says that you can postpone. You can decide at this stage of this also. So this was what we were discussing yesterday. So that comes under appreciation of documentary evidence in civil and criminal cases also. And as you said, no, you cannot give an oral account of the contents of a document. It has to prove that document itself. So anyone coming and looking at the photocopy and saying, yeah, this is this, speaking and you recording it is wrong.
This is the document which I have, this is not the oral account of what is written there and all that.
Mm.
This is the email which I have provided to the IO.
But why is it in photocopy then? Should not be. No?
No, not photocopy, this is that printed copy, print out.
Then 65B is required, even otherwise. It's required.
Sir, then in that respect, even photographs should have such.
Of course, why not?
Photographs they could have.
Digital photographs, don't go. Unless they bring the camera before you.
Camera also receive that.
So usually it's not that. What we also used to do is, we know the fate of the case by halfway, most of the time, except few, right? Nothing is going to happen, forget it.
And
Bank
bank statements also, what we see is only on the last page, the bank official gives a signature and seal, that's it.
That's
They did
inadmissible.
not make it, they did not make any endorsement. So that is
There was, I think, one vigilance case which went up to men's court. There were a lot of bank statements. I used PV Anwar and said no. I did not look at it that way. Whatever my job was done, no? Its law says so. If the appellate court would want to say something else, that's a different matter. So I think if the big one, then be happy, no? It's not there. Don't teach them. Unless you feel that, the case would fail without that and your intervention is necessary to save the justice. Otherwise, 100% acquittal case, why to insist?
Nowadays what the advocates are doing recently is they give title suit without registration. And double एक पे है sir, एक mistake by me. I mean, I'm not here to prove it, give it back. Oh, so they go prove it got in her. I'm like, please take your
Filing center. No, that practice I've seen in districts also. But I said that, forget it, don't bring to him. But every time, even after saying, they would even ask me, so, Deska would ask that, sir, bail halno ki na halno? I said, that's your right. Up to 230, it's lawyer's right. If it's beyond that, then you would ask me whether I would allow the registration or not. So those things were there. And whatever we write it in our order sheet, no? Why should we correct it before being registered, getting registered? East ma ta bhyaउँदैन, district ma bhyaउन सक्ला, I don't know, except Namchi, but East ma ta when we bhyaउँदैन नि त्यो, read गर्दैन, and that's absolutely not our job also, no? Even if we are free, is it our job to wait the petition? If it's wrong, we'll write in order, decision. We can return it. Because like we were discussing yesterday, no, in the
So, if 61B certificate is not there, then what type of discussion to ask for 61B certificate?
Yes, it has.
If it is at the end of the trial, then
depends on the discussion, I said. No?
then before argument can it be asked?
Why not?
Then again the evidence is still there.
Yes, it has to be there.
Because there is this.
Because till that time, whatever, even if you have recorded previously, it was inadmissible. No? 65B deals only with admissibility.
The question is asked to the IO, which was saying that certificate is not finding in the process. Explain that yes, this certificate is not there. I should not ask for 65B. But then the court feels that okay, 65B certificate is necessary because the antibody is needed from that.
It's absolutely necessary.
Yes. So then can it be asked?
Yes.
Anytime after
Yes.
the DW.
No, that judgment is saying, no, that.
Which one says no that the public prosecutor has the right to file documents which are necessary to court at any time before the judgment?
No, not with, I mean, could be. But with 65B, the last judgment clearly said, previous judgment said that you can file it any time. But the last judgment says, court has a discretion to get it filed any time. Or one more ground, what it says is, I'm not getting it. It can be fact, but earlier it was, there was no guidance. Prosecutor would come and file and put bringing it. But now they cannot do that. Either you should ask for it, but there's one more thing which I'm not sure. I think whether the application. Why? Everything what has been done? How it will cause prejudice? That's what, no, that should not have been asked. That's what I'm trying to do. That should not have been asked. You should not have allowed those questions to come in. Because there was no 65P at all. How can oral statement be given of it? The last judgment clearly says you cannot say anything about electronic evidence orally. So you should have stopped the witness, the question being put to the witness of all the electronic things. That's what. Yeah, no, even my experience, see, I'll tell you one of my experience in 65B, from that day, I used to tell lawyers, come and ask this question. One lawyer one day asked to it was chief done. The lawyer, it's a certificate, no? What's the value of certificate? I am certifying something, I must know its content. One thing was asked was, do you know what is written here? The fellow doesn't know. I do not know. Go on. What will I do with that 65B certificate also? Now the question is whether I should admit it just because certificate is there, even when the person is saying I do not know its content. This was a dilemma before me. And these judgments, none of the judgments so far deal with this practical problem. If the provider disowns the certificate or if he says I do not know its content, then is still those evidence admissible, even if certificate is there. Is mere production sufficient or it must be proved? So that none of the judgments deal with this aspect. It only deals with whether 65B should be there or not. So that time this judgment was not there, okay, last one. It was Sonu Amar's judgment was the last judgment which allowed, even where 65B certificate is not there, it cannot be produced, and it used certain words saying that, so it describes certain circumstances which could be enlarged by any court by relying on those words. So relying on those words, I think to save that case, I enlarged the scope because that time Sonu Amar gave it. But all these judgments are gone now. We cannot do anything. From Arjun Pandit Rao judgment, no? Tommaso Bruno, Sonu Amar, Safi Muhammad, I think Safi Muhammad, these all tried to dilute the absolute requirement of 65B. But again, Arjun Pandit Rao went back to P.V. Basil and said, no, it's required. And one more question I would pose to judges. I think it can be done, no? Let's say there's no 65B. And the only evidence available is CCTV. Can we look it at the stage of framing of charge? I think we can, no? Because we are not dealing with admissibility at that stage, in criminal law at least. We know that, it cannot be admitted, but it's still a material at that stage, no? Not a evidence. Oh, so, yes, sir, yes, sir.
If it is primary evidence, if it is the machine itself, DVR or
Then there's no problem.
RDR, along with the CCTV cameras, if it comes to your court without 65B also, I think you can take it.
Yes, primarily. No, I mean to say the photocopy of it. Let's say the output.
So, now we know what the law is saying, and what is to be admitted, what is not to be admitted. But from a judge perspective, if a case comes to you where situation is similar to mine, which I said just now,
So how do we solve that issue?
See, they've got different type of judges. I just don't care who has died or whatever has happened. Mine is that way. I see the law finished.
No, because
I have no sympathy against
one thing
or
that
for
usually-
anyone in the court.
Usually what we see is that the resource persons usually 65B, section 65B says this, we have to do this is to be complied this, the judgment is saying this. Okay, that is there. But I'm saying a person, a judge who is faced with a particular situation when there are certain things which are lacking or which is not there. For example, like I just give the example which I said. So how do the judge approach that situation?
Okay, in that situation, you feel that some material things are
Because-
there. You can, as I said, no, you can order for 65B. So discussion.
So like
If you feel
said,
that is so
you-
crucial for your
yes,
case.
you like I said in my particular situation when the question is already asked.
Yeah.
Okay, with regards to that, then how do, because I'm sure everybody here is I'm sure I'm 100%, I know that everybody here is the judge. So we will have to look from that aspect that given that situation, how do we tackle it? Because what the book says.
Now see,
we know that.
your mind is feeling is essential. Now you are thinking the accused will get prejudice. Okay, that's the only balance that is running in your mind. I am getting that feeling. But it's neither the accused or the the justness which you are feeling.
Or do I just write?
You want 65B from your heart.
For the just.
And it allows, law is also allowing. So why you are not doing it? Do it. If the accused says he is getting prejudiced, let him prove before you that I am prejudiced this way. Okay, then still you can do it. If it's still prejudiced, then that order will be set aside by the appellate court, not by you. Because you cannot do certain things which is in the authority of appellate court. You have to leave that to that.
Because criminal law everywhere it says for the just decision of the case. So I can just use that word and then I'll
311 ma? Yes, why not?
for the just decision of the case.
Oh, that's right. 311 is also there, plus the Arjun Pandit Rao judgment also says it gives you the discretion. It is not unguided, okay? You just can't order anytime or without any reasons. But it's your discretion, it says.
Sir, when you say when the machine itself is brought as a evidence in the court, for that also that has to be shown that it has to be functioning at the time of when it was
No, that those contents are not required. For admissibility. You see, that proof is a different thing. If you require the facts of the case, that whether it was working or not, if you have certain doubt, then it must be proved. But for admissibility, nothing is required to be done if they are bringing the machine itself. Finished.
So has value also only with regard to
Yeah. Because unless it is stored somewhere.
till now I don't think any of the police officers has got it.
No.
Has value and
See, to be frank enough, no? A coach will be, court ko standard त्यति नै हुन्छ जति दिन्छन्. We cannot give more output than what is given. If we are given high standards, we will give very high standard output. That's the problem, no? So our judgment somewhere or the other looks, if someone good one reads it, may find no, but it doesn't mean anything. The court is as good as the lawyers are, to be frank. We can do a little bit extra, but if we have good lawyers coming to and pushing us, then obviously we'll also have to go and research, no? Otherwise we'll write judgment with the known knowledge what we have so far, no? We'll work hard, more than required. Especially once you grow this old, I guess. Initially there's a lot of that one. You get healed by doing work, but later on all material things. Now, that's the thing, no, 65. Now, 65 being, is it a secondary evidence? I'm not talking about the real material, what is brought before you with 65B certificate. Is it a secondary evidence or not? Because this distinction is also, I think, needs to be on mind. The primary evidence, by evidence act says, 65B the kina ल्याएको त? Is it actually secondary evidence? If you read, no, it's not. Because if it was a secondary evidence, no, you had to follow all the other secondary sections of the 65 taken there. It is deemed primary, not secondary. So it has been used, that word, interchangeably, but if you see 65B itself, it says so. It says just here, okay? Last part is just relevant. It shall be admissible in any proceedings without further proof or production of the original, as evidence of any contents of the original or of any fact stated therein, of which direct evidence would be admissible. So that whatever is brought is deemed to be primary. Now one more question may come up, no, in the court. There are no judgments to this exactly on this. Suppose let's say banking documents usually comes. Okay, and then even if you see, even if 65B was not there in the law, the banking statement still required one certification under Bankers Book Evidence Act. It's same as 65B. 65B is more elaborate, but now are the bank statements which are certified under Bankers Book Evidence Act also required to be certified under 65B if the output is electronic? The Bankers Book Evidence Act also deals with electronic output of banking records. Whether we need double certification or one of them would do. Even if it's an electronic record, then you are overlooking 65B, no? 65B is a procedural law which says you cannot have any electronic record admissible without 65B. The Banker's Book is doing it. The same thing. But still, it is not doing because it is an electronic record. That law provides the manner of certification of electronic record of a bank. So do we need both, or we need just one, or 65B would do it? Just because 65B must be there, mandatory लाग्छ because see, there are judgments not on this. One of the issue which is frequently not seen in our state, police forget that. In sexual offences, whether it be adult or children, we have most of the children are tribals, but they fail to put SC/ST Act. If you have ever noticed it, only POCSO comes. So one of the questions that arose in one of the case was in another state, which court has to deal with the offence? Whether it's because both the sections are put, SC/ST and POCSO. Now which court, either POCSO court or SC/ST court, would have jurisdiction to deal with the case? The Supreme Court have said that it is the POCSO court that has to deal with it because subsequent legislation, when made, POCSO came later on after the SC/ST. Subsequent legislation, when gave special function to a court, took notice of the previous act and gave to it still. So therefore it is the POCSO court. So taking that logic, the Information Technology Act in the 2000 by amendment put the 65B in the Indian Evidence Act. Bankers Book Evidence Act is of 1891 somewhere. So this legislation creating a separate process for electronic records in the 65B is presumed to notice the previous law, and therefore the requirement of filing 65B even for bank records is mandatory in my view. Just Bankers Book will not do. Both coming, it's no problem. But if just Bankers Book and its electronic evidence, I think that 65B is required. Because that dealt with a different aspect later on. Also have noticed there are quite a lot of POCSO cases where, because the moment it's a sexual assault, any of the offences falling in the IPC, which makes SC/ST comes to play.
What is the correlation between SC/ST Act and POCSO?
The SC/ST Act, any sexual offences. Now, in the POCSO, SC/ST Act does not talk about POCSO, but it talks all about sexual assault cases, which if committed upon the person belonging to scheduled caste and scheduled tribe is an offence under SC/ST also. And it has a different punishment.
I think SC/ST is consciously not invoked because under the SC/ST Act, one of the primary requirements is that somebody is humiliated or demeaning words are spoken or whatever action is done with a conscious knowledge that the person is from that community, and I think that is one requirement, and because of this they do not invoke the provision of SC/ST Act.
I think in other states where people are Dalit people or
That could be the conscious reason, but I would say at the stage of filing of the FIR, police have no authority to determine the intention. They have to use SC/ST. Because that is a subject of investigation later on. Because if we see the SC/ST Act in the 2015, there was an amendment. It removed every word whoever intending. Intending all were removed. And post that there is a, yes, as sir said, there should be a conscious knowledge. That Supreme Court judgment still insists on that in the end at the trial, whether there was, but it removed the word intention. So it says, it is whoever knowingly, those words were used. Now that those are removed, and in one of the cases, at these earlier stage when they had gone for quashing it, the Supreme Court said that, see, those words are removed. Now that's a matter of investigation that has to be seen. Because these is a particular, I think it is a long section, no? ST, section 10 something, STUV, it's long. There it says, whoever commits offense on a person belonging, whoever commits the scheduled offenses in the IPC, the IPC, on the person belonging to ST, when they have scheduled. So it still does not say whoever knowing or intending to do this.
But that person who does it should be conscious that he has done it.
Yeah, that consciousness must
Yes,
That consciousness
to a
must
member belonging to SC and ST. Otherwise, what happens is if there is a fight between two persons, one belongs to SC and ST, one does not, then in every case SC, ST will be invoked without conscious knowledge that that person. If it is SC, ST and he has done it with an intention that he is SC, ST and with also with one intention to really attack that particular community, then
No, it does not include every offence. That's why I'm telling. This SC/ST Act includes some of the offences picked up from IPC, belonging to IPC,
Yes.
and saying this has been committed. Now, another thing, the FIR comes, assume the so-and-so committed sexual assault and so-and-so. This FIR still makes the offence under SC/ST a cognizable offence, and it has to be invoked according to because the SC/ST Act never get the power to investigating agencies to differentiate whether the act was done intending to be done upon SC. That power solely rests on the court after evidence comes up. If directly they are alleging it, then that's more clearer picture. But even if there is no allegation, I think the act has a greater objective of protecting them this way. Because even if, as we know practically, how FIRs are lost. So police could remove that, they may not put it. So I think to stop this one, the moment the person belongs to SC/ST community, this section has to be moved, to my understanding.
Sir, I am a driver. I go as TP or from family to say something back or STOP or SC.
Like that, must be from another. As far as I know.
Sir, from a
Why, sir?
maybe from a driver.
Yeah.
From an ST to SC also it doesn't.
I don't think so. SC/ST are treated
Driver
at par, I think.
Understandable. But then from a ST to
No, ST can say to ST, ST can say to SC. As far as
Wow, they are too privileged.
why it is not invoked is because most of the accused also fall under the same category.
If you see SC/ST Amendment 2015, no, it has been made very, very strict. You stopping someone to contest, to file a, what do we call it, to contest an election is also an offence if the person belongs to SC/ST. They have included everything. And they have removed that whoever knowingly, because previously intention was determined from this word knowingly spends. They have removed all those words. The last judgment says that requirement is not there, but consciousness as source requires. What it says, man? Knowledge, they remove that. Well, last person.
Any woman belong to sexual class and sexual right or sexual right will intend to dishonor or outrage her others.
So in the end, we might say that 65B is just a formal requirement. It just makes it admissible, nothing else. It does not prove the max what can be done if a giver of certificate is, he has given a false certificate, he can be prosecuted for giving false evidence. It is only that which keeps him. Otherwise, its value is not more. It just reiterates what is written out here and allows the court to accept it. That's all. The moment that is done, its value is gone. It does not prove anything. Let's say the camera. If the original camera is brought, we don't require 65p. Right? Now this has relation to the PV Basir case. PV Basir case says, it says memory card. If you bring memory card, you have to have 65p, it says. Or it gives examples of such devices which are not primary. Memory card, CD, DVD, etc. But if you see nowadays, even mobile phone or camera phone, all these larger part of the records are, barring to certain extent iPhone, are in external recording device that is there in the phone or in camera. All cameras have that memory card. Their internal storage is very, very less. All the photos was there. So if that is there inside the camera, do we still need 65p? Then why do we need it the moment we take it out from the camera? Is the same thing. It is just because it's inside the device, we don't need, the record is still in the memory card. So this is also a little bit of area which has not been covered by judgments. All original devices, let's take for example the laptop also. Its memory is allocated at a particular place. If I sever it from there, according to law, I need 65p. But if I bring it along with the device, I don't need it.
Once you take it out from the device itself, then there is always a possibility of tampering or changing the nature or character of that particular.
I could have done in the camera, let's say suppose there's a memory card which is very easy to insert and take it out. I can put something else and give it in the camera and say, see, this primary, no 65p is required. But if even in the courtroom, if I moment take it out, then it requires 65p. So it sounds little bit of illogical in this context. Because if you see, this 65p, it was never meant for these cases, never. Because in the year 2000, I think hardly anyone had computers, but offices did have computers. So if you see 65p, it talks about a person in authority is the one who should give certificate.
Right.
Now who is the person in authority nowadays of my laptop? Me. But this use of word authority, etc., shows that it meant to only those electronic devices which were there in the offices then. Only that far they could think in the law. No one would have thought that today we would be holding mobile phones in our hand, so many electronic devices with us, and CCTV camera in everyone's home. Okay, now that's what the problem. No, the 65p certificate is usually given by the one who installed the CCTV. We see that because police think that they are the expert in it, and then they make all false statements like, I was just maintaining it so and so. It was under my control. The device must be on the मालिकले केही गर्दैन मेरो कन्ट्रोलमा थियो मैले मेन्टेन गर्थे I used to see it भनेर they give that kind of evidence. But is that person still the person in authority to give certificate is also another question that has not been answered so far. Not authority also, and purporting to be signed by a person occupying a responsible official position. Now this makes it clear that this section was never intended to be made to electronic evidences coming from private arena. It's a responsible official position. I don't think anywhere is there any situation where we can use official in private affairs. So this was meant to be that way, but I do not know why. I think the only reason why it's extended nowadays is that, to make it admissible. Otherwise anyone would come with anything without any responsibility being fixed upon that. Now the certificate giver is a person in whom we can fix the responsibility if he has given a false certificate without swearing to the genuineness of the contents of this 65p. So many years going on, I do not know why this is still insisted even in judgments, making it mandatory. It was, to my understanding, it was a great scope for the Honorable Supreme Court to do away with, so that the legislature makes some good law on this. If it was just for a purpose of making it admissible. Because we have seen so many judgments being liberally interpreted to facilitate the course of justice. The court was absolutely aware that because of 65B, so many cases are getting vitiated. Still, it said it's mandatory.
For that matter, if we see the 65 just give it separately, first the first for that is when you copy or video or anything in a pen drive, it is said that you need to record the hash value also of
Yes,
that
yes.
review. So if that is the
That's why I said no.
procedure which we follow, that no case is going to get approved only. Everything will go because neither the hash value, nothing is given in the court.
No, see, then, okay, yeah, what you're trying is to, it's difficult to prove, but it's not that there being no hash value means that evidence cannot be authentic.
But how do we then confirm that it has not?
The doubt should be reasonable doubts, no? Not unreasonable doubts. Someone has to create a doubt in your mind. That's what I'm doing. The greater the input, the greater our judgments will be. If so, no one has objected and you are not doubting it, why will you still insist on hash value unless you are doubting the genuineness of it? No, your doubt. As someone challenges, then you are bound to consider it. But yes, if you have a doubt, you can say as valuable as an additional ground of throwing that document, right? But if all these things are there, then it's absolute. Then the potential of it being more genuine is more, so that judge can accept it without doubts. But just because hash value is not there or something, 65 is whenever. Apart from that, so far there is no law which says you must have this. Yes, during cross, if it comes, then it will create a doubt in you. If the expert is cross, there is no hash value. Does it mean the document could be tampered? If he said yes, then go on, you will be in doubt. He is saying yes, now you have no scope of saying no. So these are the things. And let me add a little bit on this appreciation of documentary evidence, civil and criminal cases. Now, these forensic reports, let's discuss on that also. Handwriting. How is a handwriting? In the law, see, experts are called because we are not experts in it. And the law also says that it is the expert's opinion only. It's you who have to take the decision on what has been examined. Is this possible in all? In handwriting, it's possible. That too, if the sample and the specimen and the others are quite less. If this huge, it's difficult to examine it. Because the expert gives an opinion, on the strokes, etc., so and so. You have to examine the document yourself, the forged document, on the basis of what opinion is given, and you must come to an independent conclusion that yes, it is forged. You just can't rely on opinion and say because he has said it, therefore I am accepting it. You have to examine the forged document yourself and agree with how he is concluding by the science which he has used. That is one. That judgment says so. But how can you do that in a chemical analysis?
So is it necessary to listen? Because I can't remember the section, but in the evidence that says the judge can also come.
Yes, it can. That's why it allows. But it's safer to have an opinion of expert. You can compare, no problem. Without an expert also, but that will have very less value once it reaches the appellate court, and they might frown also. They will definitely frown in today's time. And so that question came up in my mind. The development of law on experts' evidence is more so on handwriting and ballistic. But they have given a general view. And they said it's the judge who has to examine it in the end. Now, will you examine a gun? You don't know anything about it. He will say, it was fired from here. Okay, some gunpowder is seen here. Where? Here. Then you will also say, yes, it is there. It is that how you take the opinions. Otherwise, he becomes a substantive witness if we just take what he says. But how do we do this in chemical analysis? Do we have to bring to chemicals and what the expert is saying is correct, or we have to blindly believe that? Or is the chemical analyzer not an expert? According to CRPC, they are experts. So why do we believe when an expert says it turned blue? And signifying it contains this chemical. Does another substances do not turn blue? Is it exclusive that substance turns blue? We have not outruled that. So these are all things, because how this came up in my mind was one of the judgment of Honorable our High Court in Sada, where the examiner has to say everything, not just brief details. But that is, even if it is in detail, it's still an opinion, no? How do I know what she is telling is true? I have to refer to some literature. Now that literature is still an opinion.
Section of Evidence Act also gives
Presumption.
says that the expert on every occasion will not be examined also. It gives
Yeah, formal witnesses, even CRPC says, evidence of formal witnesses can be taken on affidavit also. CRPC said. No, that it says.
Once it is taken on affidavit, then what about the accused is
That's right.
cross-examined?
Have you ever seen being taken in affidavit? Because it's worthless, no? It may have worked then. Nowadays, if we do that, we'll be heavily criticized. We have to call the witness. You may not call it says, but you have to call. Unless you have such a specific situation, otherwise how will you know the other person has a right to call? Unless the accused admits, okay, I'm admitting to do, then finished. No need to call. So maybe in that time it worked. Nowadays, when the requirement of proof and the right of the accused vis-a-vis the innocence has grown so much in law, it has to be proved beyond reasonable doubt, at least on today's day. So not calling the witness is not a question at all, even if it be an expert. If anyone agrees, we have to call. Others beyond reasonable doubt, the khatam hoye. Narita is so silent today. What happened? A snake comes to a premises, a snake. So she's still in shock. Rampu. So we can, it's 12 o'clock, anything. So ma'ams can teach us also, no? So, Jyoti ma'am, Samita ma'am, even sir. And there is one Supreme Court judgment, okay, which says that corroboration to the expert's opinion is not always required. It's not a rule of law. You can convict without corroboration also. But be careful, which rarely will occur, but there is a judgment. I found in one case where there was no corroboration, somehow I found and saved that case. Yeah, that judgment says. That's what I am telling you. Otherwise, if let's say, unless I say commercial is a bad person to you, will you believe me on what I said as well? I need to give reason. So it's helping the judge to come to that independence. Yes. So you have to, the judge needs a help, no? Merely someone coming and saying me, I am expert so and so. To such an extent, if you see, the most of the cross-examination is directed to the credibility of the expert from the defense. They try to impeach that at first. So the opinion needs to help. So that's what I asked, no? How do you accept the chemical examination? You don't know whether it turns blue or green, even in ballistic. Handwriting, we can match it. Ballistic also, we may examine the gun out there, know what the experts say. There is a black color out there, which means this. Okay, there is a black color. We will go to the literature, we agree. So in the chemical, I found it quite difficult. Because we have been accepting, so has been when the expert is saying, yes, it turned blue, it means proximal, let's suppose. Judge is accepting, yes, it's proximal. But is it true?
Section 45 of the Evidence Act, it is only an opinion because in a country like ours, we don't have specific or one channel how these kind of evidence can be taken as conclusive evidence. In other countries, these experts' evidence is conclusive.
Yes.
Once an expert says that this is the result of an examination, it is conclusive. But in your country, it is an opinion.
Yes, sir.
You know why? Because in a country like ours, there is no procedure. Some may follow this, some may follow others. Some may keep an exhibit for 2 months, some may keep it for 2 years. And how that chain is kept, nobody knows. And also there is always a possibility that even the experts are hand in gloves with the accused. So therefore, it is always necessary that there has to be some kind of double checking to these kind of evidence, but not necessarily that it should be always corroborated. If you find that, because judges are not supposed to know everything, especially scientific evidence, we will not be able to understand. Let's say, for example, DNA analysis, it comes to you, you will not be able to understand the entire thing. But yes, once it comes from an expert, you take it as an evidence, and you find that if everything is all right, it can be taken as an evidence conclusive. And I think that why the reasons are required, that for, let's say for example, I've done this examination, and the process of examination are given in a separate sheets of paper as to what kind of, these days the instruments are used, what kinds of instruments are used, or for example the handwriting expert, the stroke was this side, or the stroke was that side, or the language was in this and that, so that the defense can get a copy of this and prepare if the evidence of an expert is not up to the mark, to cross-examine and to, I think, demolish these kind of evidence so that the judge can make a proper appreciation of the expert evidence as well. So that is
Yes, I also feel that the electronic evidence in our country is there's a lot of disbelief in science in our country. Because if you see IPC, CRPC, it did not deal with much electronic laws then, and we are still continuing with it. And there's a disbelief in science in our country. We believe more in other things. So even when it's a fact, so let's say suppose, an aeroplane is an electronic machine. If someone comes in court and says, I saw an aeroplane flying, okay, then should we believe it or not? On what basis, I would say, on my own experience, if I've flown. So, electronic records, if someone says, something happens this happens in a mobile, to myself understand it, I don't need a 65P certificate. But when it's tendered in evidence as a court, now let's take for example also, if there is an issue of, how the aeroplane works, and they bring some kind of machine from, they'll have to file 65P. And they'll have to prove, yes, aeroplane flies because of this in the court. So, a general disbelief I found towards science still exists in our laws. Initially the science was not very much developed even when this IPC were made. But I don't know, this is with the third world countries and developed countries. We have not been to some, big jurisdictions. We have not seen how electronic evidence, whatever we have seen is in movies only. Or fortunate few have seen it, who have become very high level High Court judges, Supreme Court judges, who usually have attended these conferences in the foreign, maybe knowing how the jurisdiction works. To be frank, people tell us, I think our friends tell us, when we talk about some laws, etc., why don't you write a book? I just say to them, I can't write a book on these things unless I know the laws of the whole world experiencing it. And most of the books, if you have seen, big judges and lawyers writing it, is all they have been to. Foreign is like a second home to them. They know the law, they can write it. So for us, as I said, the things which come to us is very substandard. I still feel that, if we strictly go by law, that's I think the predicament Jammin faces every day. She wants to do exactly according to law, but the things that are coming to there, if she sticks to it, I felt this, then you will be acquitting all the cases. So standard, if our standard of prima facie belief, I feel that is so poor that we let in 60% of the case which have no standard to go to trial. I feel that way. I always felt this. And we are just in prima facie. And believe me, in 239 or 229, there's no word prima facie. It says the materials. Again, the materials means not the story of the IU on the charge sheet. It's what is behind that 161 and what he has gathered. We overlook that and then stick to what the story is, whose basis is not there in the charge sheet at all. This happened. I was telling correctly, this happened, that happened. But he has not collected to prove that. And we say, oh, prima facie is there. So, at 229's prima facie is not that to my understanding. It means there must be a presumption that the accused has committed the offence. You must have the ground to presume. Section says so. So prima facie, to my understanding, is a corollary of presumption. You must have the ground to presume he has पढ्दाखेरि चाहिँ and with the evidence, offender चाहिँ यही हो भन्नु हुनुपर्छ त्यो स्टेजमा. If you don't have that, it should be discharged. But if you go by that, 60% accused will be outside. So our standard depends on what is being given and how we adjust to it. I feel that way. So that's why that's just the chain of circumstances. All these are valuable things in a criminal law. After seizure, if the law says it has to be reported to a magistrate. The moment seizure is made, it has to be reported, which is never reported. It proves the sanctity of the seizure. Right, and forget about chain of circumstances. Where it comes, we don't know. So we are overlooking all this. No? If you stick to chain of circumstances, no seizure will get proved out here. It's doubt tempered. We can write judgments that way, no problem. But everyone should write that way, including the appellate courts. One writing will not. It will not. And we have, as I said, we'll work that hard when what is given to you is of so substandard. We'll write it superficially if everyone agrees. Okay, so I am done. The problem with the police and us is, police have examined the witnesses. I always told them, you are bringing the case to a person who has seen nothing. You must prove it before me. They know it, this fellow has done the offense, and they have that belief in their mind, and they think that, we are not understanding what they are saying. उनीहरूलाई त विटनेसले 161 लिँदा अक्युजले भनेको हुन्छ कस्टडीमा yes I did it. So they are 100% sure this is the person, but they have to bring evidence to prove that and put it in the charge sheet, which they do not do. Their belief is sufficient to file a charge sheet. That's the only problem I solve with that.
Yes.